No, I would like to come back on what maybe it's for you, Vasko, and for Professor Voorhoof. It's not that I want to exclude you. No, you were talking about the presumption of innocence, and at least in Switzerland, I think it's not the case. It can also be the case in other places. I see very often awful articles by journalists or awful statements on TV by the media on people that are eventually accused of having committed something, and they always add the sentence, but Mr. Voorhoof, he is presumed innocent. And by saying that, the journalists have the impression that everything is fine. Is this a correct way of looking at things, or do you have another opinion on that?
Well, I think it's more complex than that, but I understand your question. My answer would be that in general there is the right to report about important things which are under investigation. When it's about serious crime, when it's about public officials being involved, then I think it's the task of the media to do that. That can damage the reputation. That can maybe in the perception of the person themselves create the perception that their presumption of innocence is damaged. But here I would say the right of reporting about these cases prevails over the damage that is done in terms of reputation. But I agree with you that in many other cases, there is no need to have so much media coverage about private persons, about, let's say, daily crime, which is also serious for the victims, of course, but that there is an over-coverage and not sufficient reluctance by the journalists to report on that. And that was also precisely my recommendation, that the self-regulation, in some countries it's co-regulation on press ethics plays an important role, because the code of ethics in different countries contains many provisions on how to report about victims, about suspects, about children. There are what is the stage of the prosecution? Is there already a reference to the court? Is it only a police investigation? Is it already at the level of the public prosecutor? All these elements play a role which make that the media can go a bit further in their reporting when there is a public interest involved. And then adding the sentence, I think it's good that they add the sentence that the public is aware that for the further proceedings of the case, the persons are presumed innocent. But that doesn't take away the need to inform the public of ongoing cases.
We have one online participants, Risto Sepp, judicial officer from Estonia. You can have the floor.
It's or bailiff, as one may understand or refer to, from Estonia. Thank you for the fascinating presentations. I do agree that we need more transparency instead of secrecy with communication with media. Let me give you an example as a spokesperson of judicial officers. 10 years ago, I suggested to Estonian Chamber of Judicial Officers and Trustees in bankruptcy the need to change public image of bailiffs. And I was given an opportunity to create a working group, which we named Media and Public Relations. And the first national TV interview I gave left huge impression on me. After an interview, the journalist said to me that thanks to God, we have now source to judicial officers and someone to turn to and ask explanations. And I understood why our profession suffered under negative impression. We did not simply communicate with media at all. And journalists wrote how they usually understood the topic, meaning usually from the point of view of the debtor. Also, I would like to agree that media is sometimes too investigative, perhaps, but we must not restrict the rights or freedom for the words. We must cooperate with media. Media can broaden the understanding of profession or the possibilities. And giving to you another example is that 7 years ago, I had just annually one case in communication with a child, just problems between two adults. And we had several writings in media afterwards about mentioned topic. And today I have at least one case in child communication per month. So without media rights, to turn to court was previously just simply unknown. Thank you.
Thank you very much. Any other question? So I maybe have a last one. This morning, and this last intervention also goes in this direction. This morning we spoke a lot about medias, justice, judges, how to explain decisions. And this afternoon we focused maybe more on what happened in the first part of a case. I mean, in particular in criminal case, but it can also happen from time to time in civil cases during the investigation. And I have the impression that, but I would like to ask you if you share this impression, that the approach is not the same whether you talk about relations between the authorities, to say it in general, and the media in the first part of first critical part of an investigation, and what happens when a case gets to the end and when the judgment is being rendered.
Well, in my country, there are cases that haven't been resolved to the final verdict for 16 years. Can you believe so much time not to have any info in the public? I am aware that maybe the main focus and the main energy was focused when the first sentence verdict was announced in the court, and after that, it lost somehow the interest of this specific case. I would like to say that maybe the appellate court and the Supreme Court must be, according to my view, more open to the public, because the focal point is the criminal court in Skopje, because 80% of the cases are there. And we are not so much interested in the appellate courts and in the Supreme Courts. They have public hearings sometimes, but not. But it depends on the case, I would say. But I think that we need to work now in North Macedonia. There's still an ongoing procedure of the amendments of the criminal law, and I hope that will some legal provisions over the openness of the Supreme Court and the appellate court. So I'm not sure if I answered to the question, but I would like to say that yes, the main focus is the first circle, the second and the third not so much.
Actually, I would just like to comment it. For me, what works is work with standard media. This is what we are used to when journalists, as I could hear from colleagues that joined our discussion, they are curious the way it should work. They won't really put objective, if it can be, information to public. What is real problem are social media, and this is something that has no solution, I would say. And for the trial, of course, we respect open trial information, everything that was told through the presentation concerning principles built by ECHR. This is not something that we refuse. What we are afraid is that the fair trial will be completely disrupted by streaming or commenting directly from the hearing room. So then you can't rely on witnesses and these things that are done mostly by social media. So for me, it's not about media and information done the professional way. But for me, it is not the work, but because it's not work, it's not job, by the approach of citizen observant sitting in the hearing room and being kind of media. So that's what I consider to be biggest problem, not openness of the trial or cooperation with standard media. for me, it's threat of social media mostly.
I would also like to have two elements to add to your question. For instance, what I find disturbing in the media coverage is a discussion at the end, when there is a verdict, when there is a judgment, on the sanctions. That media start to comment that a fine is not enough, it should be a prison sentence, or a suspended sentence is not acceptable, etc. I think they don't have the full overview of the criminal records of the person involved. The court mostly has good reasons to apply a certain sanction in concrete cases. I don't think that the media should start discussing about that. And another thing I see is that in a few cases, also in Belgium and in other countries, at the end of the case, the court takes into consideration the fact that the defendant or the convicted person has already been confronted with some media coverage, that there has been some trial by media, and that is an argument to reduce the sentence. I don't think that's a good development, because that would mean that as a public person you could hope that you get a lot of media coverage, because then at the end by the court you will have a more lenient sanction. So that is something I think also to take into consideration.
Okay. Thank you very much. I will simply finish with a final something I would like to say at the end. It's more or less something I witnessed in the last months. A very, very good friend of mine, he just retired 3 weeks ago. He was judged in a very emotional case in Lausanne. The case was there were five policemen were brought before court because when they arrested a black refugee, by unluck or whatever, this refugee died. So they were all brought to court accused of homicide. And the pressure that this judge had was above him was incredible. I mean, he was really, and I think he was over the burnout, because the pressure was so high. But he managed to finalize this case in a very good way. And the day before he lectured the judgment, I went for a big walk with him, and he told me something. I think he told me something. You know, it was I had a very hard time, but we are not used to that. We are not protected. We are not protected. And I would have liked to have people around me, judges or on the office, to help me going through that very important period. And when you said that you need unbiased lawyers, judges, they also need this kind of protection, because this is also very important for good functioning justice system, that judges can also be independent and are not submitted to pressures, and also pressures from media and some kind of medias. I think we will finish with this small statement. Thank you very much.
Thank you.